In this order, they talk about how timelines don't match up, mistakes in other cases, and we're going to have some sanctions for the use of AI that cited cases that do not exist and incorrectly cited cases that do exist. Mike Lindell's lawyers have been sanctioned. Now, the background to this is essentially there was an order put in place that all of the motions in limine would be discussed at the final pre-trial trial preparation conference, and when that happened, they found nearly 30 defective citations in the defendant's opposition. So the reason it was so delayed from the filing and being discussed is because it wasn't actually brought up until that final preparation conference. Now, Christopher Kachouroff, I believe that's the name, that man might sound familiar to you, because if you take his name and add the word pants to it, you will find video where he went viral for walking around in a virtual court hearing without pants on. He only brings the best to court, Mike Lindell. After counsel for Dr. Coomer argued on his behalf with respect to the motion in limine, the court provided Mr. Kachouroff an opportunity to respond on behalf of defendants. Although Mr. Kachouroff equivocated about whether he was prepared to argue the motion in limine, he substantively argued the issues. Only after Mr. Kachouroff concluded his argument and inquired whether there was anything else the court would like me to address, did the court raise several questions regarding the opposition. So they basically hung him out to dry. They let him talk himself off a cliff. The discussed errors included, but were not limited to, misquotes of cited cases, misrepresentations of principles of law associated with cited cases, including discussing of legal principles that simply do not appear within such decisions, misstatements regarding whether case law originated from a binding authority, such as the United States Court of Appeals for the 10th Circuit, misattributions of case law to the district, and most egregiously, citations of cases that do not exist. That is a problem. The court omitted at least two errors from its discussion at the final pretrial trial preparation conference. First, the court did not address a misquotation from Worldwide Asin of Specialty Programs v. Pure Inc. I kind of want to know what that case was. The opposition used the parenthetical recognizing that reputation and character are intrinsically intertwined in defamation cases, but the quotation, reputation and character are intrinsically intertwined, does not appear in Pure. I like how they went with Pure instead of, Worldwide Asin. Second, the court did not alert defendants to an inaccurate citations on United States v. Reeves. Reeves' erroneous citation. Reeves does not support the proposition that courts recognize that evidence often serves multiple purposes and implicates multiple evidentiary rules. As for the errors the court did discuss at the final pretrial trial preparation conference, he was unable to respond in a manner that was satisfactory to the court. Specifically, he indicated he had delegated citation checking for the opposition to his co-counsel, Jennifer DeMaster. So he's blaming her. Mr. Kachouroff agreed that both he and Ms. DeMaster had signed and certified the opposition for purposes of Rule 11 of the Federal Rules of Civil Procedure. In addition, the court had the following colloquy with Mr. Kachouroff. So before that, we have here, the opposition also identified Douglas G. Warlow and Jeremiah D. Pillen. As the court noted in the order to show cause, these individuals appear to be in-house counsel for the defendant MyPillow Inc., but neither have entered an appearance in this case. Mr. Pillen does not appear to be a member of the bar of the United States District Court for Colorado. Mr. Warlow has since withdrawn from this case. So here's the talking court. The court says, was this motion generated by generative artificial intelligence? Mr. Kachouroff, not initially. Initially, I did an outline for myself and I drafted a motion. Then we ran it through AI and the court. And did you double check any of these citations once it was run through artificial intelligence? Mr. Kachouroff, Your Honor, I personally did not check it. I am responsible for it not being checked. The court. And you understand as an officer of the court, pursuant to Rule 11, Mr. Kachouroff, I did, Your Honor, the court, if you're going to use generative artificial intelligence, that does not excuse you from the obligations of Rule 11. Mr. Kachouroff, absolutely not. Absolutely not. You understand that, correct? Yes, I did, Your Honor. And that doesn't seem to have happened here, does it? No, Your Honor. At no time did Mr. Kachouroff indicate that he did not understand what generative artificial intelligence referred to or ask for a clarification. Based on the deficiencies in the opposition, the lack of explanation during the final pretrial trial preparation conference, the court ordered Mr. Kachouroff and Ms. DeMaster to show cause for why they should not be sanctioned, and referred to their respective state bars for disciplinary proceedings. On April 25th, 2025, Mr. Kachouroff and Ms. DeMaster submitted their response to the order to show cause, accompanied inter alia by a declaration from each of them. In that response, defendant represented that the counsel was unaware of any errors or issues with his response. So, filed 55 days earlier and had no reasonable opportunity to investigate any problems to be able to engage in constructive discussion about document number 283. So they're arguing that they weren't aware and it was filed 55 days earlier and they didn't have time to investigate it. I mean, you had 55 days to be familiar with what you've submitted to court. Defendants further asserted that after hearing and having a subsequent opportunity to investigate document 283, it was immediately clear that the document filed was not the correct version. It was a prior draft. It was inadvertent and erroneous filing that was not done intentionally, and it was filed mistakenly through human error. So they're blaming someone. Counsel acted swiftly to rectify the error. Defendants submitted additional materials for the court's consideration and certified that the record is complete with respect to the order to show cause. For the following reasons, the court respectfully concludes that sanctions are warranted against Mr. Kachouroff and the law firm of McSweeney, Sinkar, however you pronounce all that, jointly and severally, and against Ms. DeMaster individually. So, didn't work. The excuse did not work. Rule 11 of the Federal Rules of Civil Procedure. By presenting the court of pleading, written motion, I'm not going to read all of that. We're going to keep going through. Talk about a fake opinion. Record before the court. Despite Mr. Kachouroff's concessions during the first pretrial and trial preparation conference, both in response to the order and show cause, Mr. Kachouroff's declaration take on a puzzlingly defiant tone and tenor. The response suggests that the court improperly and unreasonably expected counsel to be prepared to address the substance of the opposition to the motion in limine, including the legal authority upon which defendant's argument was based, after he acknowledged that he was lead counsel and signing the pleading, and after the trial preparation order expressly indicated that such matters would be discussed. And they even quote, "I must respectfully submit that it was unfair for the court to continue to rapidly examine me with detailed questions about this document and posture, when I was clearly confused by the document that was before the court." Yeah, you were there to talk about that document. That was your job that day. Mr. Kachouroff's attempt to shift responsibility for counsel's failure to properly review and file defendant's opposition is both troubling and not well taken. Contrary to counsel's contention, Rule 11 does not require the court to provide advance notice or a safe harbor before issuing an order to show cause why conduct specifically described in the order has not violated Rule 11b. Instead, counsel has an affirmative duty without any prompting from the court to comply with Rule 11 and all other federal rules of civil procedure. Indeed, the Supreme Court has held that the filing of papers without taking the necessary care in their preparation is a separate abuse of the judicial system subject to a separate sanction. So yeah, the whole, we filed the wrong document, that's sanctionable. And here we have footnote. The court is unpersuaded by Mr. Kachouroff's attempt to distinguish the terms discussed and formally argued from each other. Either term respects the expectation that the counsel be prepared to address substantially any outstanding disputes regarding the admissibility of evidence raised by the motion in limine in response at the final pretrial trial preparation conference. To the extent that Mr. Kachouroff was unclear about his obligations beyond the court's language, Rule 16 of the Federal Rules of Civil Procedure provides express guidance in parts. At any pretrial conference, the court may consider and take appropriate action on the following matters: obtaining admissions and stipulations about facts and documents to avoid unnecessary proofs, and ruling in advance on the admissibility of evidence, as well as disposing of any pending motions. Oh boy. And despite Mr. Kachouroff's suggestion, the court did not blindside defendants with a public written order to show cause. Rather, the court offered Mr. Kachouroff the opportunity to explain the errors in opposition before the court issued a written order. In any case, the court has given defense counsel an opportunity to show cause, And now it turns to the substance of their response. And this is their submission of a draft. Defense counsel submits that Exhibit A to their response is the correct response to plaintiff's motion in limine, which is submitted without alteration and does not include a completed certificate of service. They further contend that the mistaken filing occurred under circumstances which were entirely inadvertent. For example, the day prior to filing of the wrong version, defense counsel worked together to remove troublesome citations and shore up the main argument. Mr. Kachouroff declares, under penalty of perjury, that between February 22nd and March 1st, 2025, I was on a long overdue 1-week vacation in Mexico with my family. It's just so funny to me because I was literally just reading about Ted Cruz, who every time there's a disaster, he's on vacation, and he is again. Nevertheless, during that time, Mrs. DeMaster and I completed final revisions on our opposition, going through each page to check both the argument and verify the case citations. Because of the limitations on internet service where I was located, as we confirmed deletions and edit, Mrs. DeMaster simultaneously completed a citation check using her Westlaw account. Again, he seems like he's blaming co-counsel at this point. Mrs. DeMaster also sent me a Westlaw citation report that allowed me to compare the citations in the Westlaw report with those of the opposition. Correspondence for confirming our work together and her Westlaw citation report is attached to Exhibit C for our motion for leave. These emails are true and correct copies of communication between myself and Ms. DeMaster. I printed the drafts out and closely reviewed the final version to be filed. Here we have emphasis added. Ms. DeMaster declares under penalty of perjury that the correct version that should have been filed was titled 25.02.24 Coomer Def's Opposition ML2 JD-copy. Ms. DeMaster further declares, I have included 2 true and accurate screenshots of the document properties for the 2 versions as Exhibit D to defendant's motion for leave to show the time edits to both versions of the documents. Now, to be clear, I believe you can edit those if you really wanted to, those time numbers. I mean, it is a document. I believe you can edit the timestamps. I'm not saying they did it, but I am saying it's not the best proof. As can be seen, the last edit was done due to the incorrect version was edited for 6 minutes. The purpose of that very brief edit was to ensure the certificate of service data was filled out and the court caption was changed to Colorado. In sum, the defense counsel contended they mistakenly filed MIL 25 blah blah blah, which contains erroneous citations instead of the corrected copy. To evaluate counsel's representation, this court attempts to square counsel's representations with the documentary record before it. The data from the filed CM ECF system related to the filed version. Okay, let's take a look here. All right, so this is the verified signature. The filed version refers to plaintiff as Mr. Coomer. The filed version also reflects the District of Colorado in the case caption. Preparation of the filed version. The day before the filing, February 24th, Ms. DeMaster sent Mr. Kachouroff an email with the timestamp 5:08 p.m., attaching it with a filed size of 53K and a Westlaw report. Given the naming convention, this version was likely the base document of the filed opposition. The message from Ms. DeMaster to Mr. Kachouroff reads, final citations, final revisions, full document with formatting here. Didn't flag it for any obviously bad case law. As discussed above, Ms. Kachouroff refers to the attached document. Ms. DeMaster's declaration similarly states that this final version as sent to Mr. Kachouroff reflects the edits and citation checks that she and Mr. Kachouroff made over the phone, but the final version of the opposition is substantially the same as the one filed. And it again refers to plaintiff as Mr. Coomer. It reflects the District of Colorado in the caption. The final version of the opposition that Mr. Kachouroff reviewed does not, however, reflect any edits that now appear in the correct version. Oh! So that's where we were getting. Let's repeat that. The final version of the opposition that Mr. Kachouroff reviewed does not, however, reflect any edits that now appear in the correct version. And it is replete with the same errors as the filed version. For instance, Coomer, Def's whatever, still misattributes the case of Ginter v. that to the District of Colorado. It includes 2 errors the court did not bring to the defendant's attention during the final pretrial preparation conference. Now, isn't that interesting? Isn't that fascinating? So the claim, for anyone that's maybe a little lost, because a lot of wording there, The claim is that they had a newer, updated version of the document and an old version was submitted. But the new version that they claim is correct, that version didn't fix the things they weren't told about, and it doesn't seem to match up, according to the court, with the emails they claim prove that they actually had a corrected version. Oh. It sounds like the version they're saying was correct would actually still get them sanctioned. Wow. The pure misquote in the Reed's erroneous citation, it also contains 3 citations to non-existent cases were contained in the filed version. So they still have citations to non-existent cases. Put simply, neither defense counsel's communication or the final version of the opposition that they reviews corroborate the existence of the correct version. Remember, they're saying this was said. This could be perjury. That's what they're accusing them of right now, essentially. This is the court saying, you said this under penalty of perjury. This doesn't match that story. Your evidence doesn't support it. Yikes. The overlapping errors between the final version of the opposition and the filed version also undercut several defense counsel's representations. For one, the citations to Perkins, Martinelli, and Hoffman contradict Mr. Cachouroff's statement that I do not rely on AI to do legal research or find cases. Mr. Kachouroff further states, I did not understand what was going on because my co-counsel and I had not relied on AI legal research and had prepared a thoroughly site-checked final document to be filed as our opposition. But this statement does not square with Miss DeMaster's declaration so they're now saying, look, the guy said this, but she said something different. During multiple lengthy phone calls, we discussed the problems of the case citations which have been added to the drafts. Mr. Kachouroff told me he had been focused on the logic of the arguments and believed some of these citations were likely from AI drafts, and he wanted them deleted. So even their defense isn't. Their story they use as a defense doesn't match. Both of us were concerned about the reliability. I told him I would check the citations and use Westlaw to validate authority, see Exhibit C. We also discussed the viability of certain arguments. Although eliminated from the proffered correct opposition, neither Mr. Kachouroff nor Ms. DeMaster provide the court with any explanation as to how those citations appeared in any draft of the opposition absent the use of generative artificial intelligence or gross carelessness by counsel. Given this email and its attachments, it is not clear to the court how Mr. Kachouroff could be shocked by the court's inquiry or unfamiliar with the 17-page filed opposition when the final draft is substantially the same as the filed opposition, which was undisputably sent to Mr. Kachouroff, presumably reviewed in detail, and with the last documented version of the opposition exchanged between counsel. Even if Mr. Kachouroff relies on Ms. DeMaster to finish editing and filing the document, blind reliance on another attorney can be an improper delegation of an attorney's non-delegible responsibility under Rule 11. They're saying even if your story is true, it sounds like sanctions. The record contains no contemporaneousness written communication reflecting any edits made after February 24, 2025, communication at 5:08 p.m., prior to filing the opposition on February 25th, 2025. Yeah. And here we have prior version of the opposition exchange between Mr. Kachouroff and Ms. DeMaster, where the file size of 49K is attached. Although Ms. DeMaster's message refers to finding and replacing a few cases that were not accurate or properly cited, this document includes most of the same exemplar errors discussed above. Like he filed the filed version, this version of the opposition also refers to plaintiff as Mr. Coomer and correctly identifies the District of Colorado in its caption, but it does not reflect any of the extensive edits that were ultimately contained in the correct version. So basically they're saying there's a filed version, there's what they claim is emails proving an edited version they were working on. That version still contains errors, and it doesn't match their new filed version. This is a lot. They went rough. They went hard. They are not playing. Now they're talking about the correct version. Counsel represented they had developed the correct version of the response. Curiously, the appendix included with the backline draft the correct brief refers to notes of changes from final rough draft to final version that was worked on April 24th and completed on April 25th and finalized at approximately 4:10 p.m. CST. Bold and original, underline added. April 24th and 25th, 2025 refers to the time period between the Council's issuance of the order to show cause on April 23rd and the filing of defendant's response, not the time period during editing or before the defendant's opposition. So they're calling out the editing timelines not matching. And they says this court assumes the defense counsel would contend that this statement is simply a typographical error. I'm sure they would. But there is no evidence in the record of any version of any similar naming convention, which would presumably have been in the base document before a copy was made. And importantly, there is no evidence that any document using a naming convention consistent with the correct version or containing extensive edits containing the correct version was exchanged between Mr. Kachouroff and Mr. DeMaster on or around February 25th, 24th, 2025. The version with the closest naming conviction was the one attached the counsel's 2:42 p.m. email. But it's clear from the correspondence between counsel, this is an earlier version than the 2025-224 version. The correct version of the opposition still has substantive errors, beginning with the case caption that reads the United States District Court for the District of Cite District. It is difficult to square this version being the later correct one with such an error that was not present in either the filed version that was presumably a draft or the other earlier version in the record. Yikes. The correct opposition also refers to Dr. Coomer instead of Mr. Coomer, despite Mr. Kachouroff's argument that referring to the plaintiff as Dr. Coomer was improper bolstering. Court ultimately rejected this argument for lack of authority. So, yikes. The two errors that the court omitted from this discussion with Mr. Kachouroff during the final pretrial preparation conference. So, they're getting like every little thing is just nailing them. Like, you called him Mr., and we told you have to call him by doctor, but then in this version, you're calling him by doctor, and it doesn't make sense for the timeline because back then you were calling him Mr., and it says Cite District. Why does it say Cite District if this is an updated version of something that had the correct district? Some errors that were specifically discussed during the conference also remain in the correct version. For instance, the correct version still relies on the Perrin v. Anderson, but Perrin is a civil rights, not defamation case, and says nothing about whether courts routinely admit evidence probative of truthfulness in defamation actions. Rather, the only reference to defamation is an example of where the existence or non-existence of a character trait may directly at issue because the trait itself determines the rights and liabilities of the parties. So again, citations that shouldn't have been in there. In a defamation action, for example, the plaintiff's reputation for honesty is directly at issue when the defendant has called the plaintiff dishonest. Further, the correct opposition again misattributes United States v. Hassan to the 10th Circuit, which is the case United States Court of Appeals. This error is material because unlike 10th Circuit cases, 4 circuits are not binding on this court. And United States v. Reeves is still described as parenthetical as analyzing evidence under multiple rules will it serve overlapping purposes, when in actuality the opinion only discusses Rule 608B of the Federal Rules of Evidence on a different page. Moreover, to the extent defense counsel suggests that the Westlaw report satisfied the Rule 11B duties with respect to confirming that their legal contentions were warranted by existing law, that Westlaw report was generated against 224, whatever, the correct version. Instead, despite Mr. Kachouroff's insistence that prior to the pretrial conference, I refused to correct opposition multiple times, including on my way to the funeral of a family member. Oh my God. So he's trying to use family funeral as a sympathy. Who had tragically and unexpectedly died March 27, 2025. Well, isn't that interesting? I believe the arguments were sound arguments and compiled with Federal Rule Civil Procedure 11B. Emphasis added, there is no evidence in the record of when or how Mr. Kachouroff ever obtained the correct version of the opposition to review prior to its submission on February 25th, 2025, or prior to March 27, 2025. Yikes. And now we're at like general practice. So we're getting hard. This has been rough. It's rough to read, but like take a moment and really think about what they're claiming right here. This is to lawyers who just lost a case. I wonder if Mike Lindell could in any way go after them because this happened in his case. I don't know. I'm interested in that. Finally, this court turns to Mr. Kachouroff's statement that document 283 represents a clear deviation from what my practice has been, and given the number of errors, it's just as reasonable to presume the document could have been a mistake, specifically when I commented during the hearing that it must be a draft. But this assertion is believed by similar conduct is belied by similar conduct before a different federal court. Oh. Similar conduct? The court takes judicial notice that just 7 days after this court issued the order to show cause, the same defense counsel team quietly filed 2 notice of errata regarding their briefing in Pelishek v. City of Sheboygan. Those errata demonstrate the same type of errors in the filed opposition, including citations to cases that do not exist. Oh my God, they were doing it in multiple cases. Oh my God. As discussing falsified government records affecting taxpayer funds when no such quotes exist in the case. The first filing of notice of errata, ECF 125, refers to plaintiff's brief. Wow. I don't know if, I would love to have, lawyer, dive into this, an actual lawyer, and, tell everyone, how screwed are you if you're doing this in multiple cases at once? Sanctions. All right. This is the part probably everyone's really here for. Based on the record before it, and for the reasons stated herein, this court finds that Mr. Kachouroff and Ms. DeMaster have violated Rule 11 because they were not reasonable in certifying that the claims, defenses, and other legal contentions contained in defendant's opposition and motion in limine were warranted by existing law or by non-frivolous argument for extending, modifying, or reversing existing law, or for establishing new law. Nor is this court persuaded by counsel's contention that the correct version was prepared and ready to file on February 25th, 2025, and the filing of the opposition at document 2083 was simply an inadvertent error given the contradictory statements and the lack of corroborating evidence. Notwithstanding any suggestion to the contrary, this court derives no joy, I think they do, from sanctioning attorneys who appear before it. Indeed, federal courts rely upon the assistance of attorneys as officers of the court for the efficient and fair administration of justice. See Goldfarb v. State Bar. Nevertheless, the court is entitled to expect a reasonable level of competence and care on the part of the attorneys who appear before it, and it's to expect that claims submitted for adjudication by those attorneys have a rational basis. This standard was not met here with the filing of defendant's opposition to plaintiff's motion in limine. Thus, the court now turns to the appropriate sanction. Rule 11 sanctions are meant to serve several purposes, including deterring future litigation abuse, punishing present litigation abuse, compensating victims of litigation abuse, streamlining court documents, and facilitating case management with deterrence as the primary goal. Though not bound by other court districts, this court finds that a sanction of $3,000 against Christopher L. Kachouroff, law firm McSweeney, jointly and severally, and the $3,000 against Ms. DeMaster individually is the least severe sanction adequate. I mean, it sounds inadequate to me, but I'm not the judge, to deter and punish defense counsel in this instance. Because Mr. Kachouroff confirmed that he did not advise counsel that I use a myriad of AI tools in my practice, such as Microsoft Word's Copilot, Westlaw's AI, Google's Gemini, X's Grok, Claude, ChatGPT, Perplexity, and others. Oh my God, why are you using those on court documents if you're not checking? This court does not extend the sanction to defendants, Michael J. Lindell, Frank's speech. So, Mike Lindell doesn't get sanctioned because Mike Lindell did not know. So, they got $3,000 sanction each. I think we can agree that that sanction is a slap on the wrist. I would say that. Now, the big thing is going to be, who's going to hire them? Right? They didn't just do it in this case, according to this by the judge. There was another case, and they had to go in after they got called out for this case. Who is going to hire these people? Now, Are they going to find work? Yes. Why do I say that? Remember, Kachouroff is famous for being pantsless on a court broadcast. It was one of those Zoom courts when they were first starting. So he'll find someone, but I don't think I wouldn't trust him with anything big. Tell me what you think. I think they could have had a bigger sanction. I'm really interested to see if Mike Lindell goes for them. He's kind of needing money right now, so we'll see. And I'll see you in the next video.